Okay, good afternoon, everyone, and of course, good morning or good evening to those that are joining from other parts of the world. It's so great to have you join us for this event hosted by the Forum on Decentering the Human, which is a new research center at Queen Mary, University of London. I'm delighted that we have two amazing speakers. We have Raphael Fazel and we have Josh Gellers, who will be speaking on AI rights or robot rights. And the title of Raphael's talk is Robot Rights Without Human Frights. So to introduce the event today, I'm going to first give a bio of the speakers. Raphael will then have about 20 minutes to speak. And Josh will give a 15 minutes or so response, followed by another response by Raphael for up to 5 minutes. And then we will have a Q&A session. We hope to finish around 3:30, but definitely not later than 3:30, though we may finish beforehand. The talk by Raphael and Josh will be recorded, whereas the Q&A will not. Okay, so now to introduce our amazing speakers. First, we have Dr. Raphael Fazel, who is currently the Yates Glazebrook Fellow and Director of Studies in Law at Jesus College and affiliated lecturer at the Cambridge Law Faculty. He specializes in public law with a particular interest in constitutional theory, human rights law, and animal rights law. Raphael was previously a fellow in law at the LSE, and he's held numerous visiting positions, including at Yale, NYU, Harvard, etc. He is the author of two forthcoming books, one entitled More Equal Than Others, Humans and the Rights of Others, which is forthcoming next year with OUP, and another forthcoming book, together with myself, Animals and the Constitution, again forthcoming with OUP, hopefully sometime next year or very early the year after. He's also the co-author with Sean Butler with Animal Rights Law, which is a textbook that focuses on the same title and is readily available, and it's a great textbook that I highly recommend to students. Okay, then we have Dr. Josh Gellers, who is Professor and Director of the MA in International Affairs program in the Department of Political Science and Public Administration at the University of North Florida. He is also a Research Fellow of the Earth System Governance Project, expert with the Global AI Ethics Institute, a member of the IEEE Working Group on Design-Centered Human-Robot Interaction and Governance. Josh's research focuses on environmental governance, rights, and technology, and he has published widely, including 24 articles or chapters, edited a special issue of Earth System Governance on AI and digitalization, and he has written two really wonderful books. The first is The Global Emergence of Constitutional Environmental Rights, which is a 2017 book, which I highly recommend, and I also highly recommend The Rights for Robots, Artificial Intelligence, Animal and Environmental Law, which was published in 2020 by Routledge. Okay, now that I've introduced our amazing speakers, please please join me in welcoming Raphael to speak for about 20 minutes. Thank you all.
Great. Well, thanks a lot, John, for organizing this event and for giving me the opportunity to talk about my research. And thanks to everyone for joining today. My paper, as John said, is entitled Robot Rights Without Human Frights. It's maybe a bit of a cheeky title, as we'll see later on, but here we are. The paper is a spin-off of my forthcoming book that John's kindly alluded to as well, called More Equal Than Others, Humans and the Rights of Other Animals, which deals with human and animal rights, as the title suggests. Those of you who have had a chance to read the draft paper will have noticed that it is still in a quite rough state. So I'll be grateful for any kind of feedback that you might have and I'll look forward to the discussion with you later on. For those of you who have not read the paper or who need a refresher, I'll use the next 19 or so minutes to summarize its main ideas in 4 steps. First, I will set the stage by explaining why the issue of robot rights and its relationship with human rights is really worth our attention. Second, I will describe the threat that a particular robot rights approach poses to human rights. The approach I focus on grounds robot rights in individual robots' characteristics or interests, and I will be referring to it as the individual characteristics approach. So that's my focus. Third, I will outline the species membership approach. This is a proposal that I developed in the animal rights context in the book I mentioned earlier. And really, I developed it to tackle a similar threat that the individual characteristics-based approach poses to human rights in that context. And then fourth and finally, I will sketch how the species membership approach, or SMA, can be applied to robots. Before I start, though, just some brief provisos. Note that my focus for the most part will be on legal rights. And by that, I roughly mean fundamental rights akin to human rights. I focus on robots, that is embodied AIs, in particular intelligent embodied AIs, because I think them to have the best chance at acquiring rights grounding properties such as sentience at some point. But ultimately, I remain non-committal as to whether robots will ever really acquire such properties. I just don't know. Okay, so with this out of the way, the first part is for us to consider why exactly we should focus on robot rights and the relationship with human rights in the first place. In other words, why are you here and why shouldn't you just be leaving this room? The starting point of my paper is a recent shift that we are witnessing in AI scholarship. Really, for quite a long time, debates on the ethical and legal implications of AIs were centered on the threat that AIs pose to humans, right? So this anthropocentric focus, for instance, is mirrored in the fact that the fields of robot ethics and machine ethics are not concerned with the ethical treatment of AIs, but of the ethical treatment of humans by AIs, right? So the name might be a bit misleading here, robot ethics, machine ethics, but here we go. But some scholars have started to argue that maybe we should be taking robots' rights more seriously. So David Gunkel, for instance, has called this the other question, namely, I quote, can and should robots have rights, end of quote, robots themselves. And really with the fast-paced developments that we're seeing in artificial intelligence, in robot technology, this likelihood of artificial intelligences requiring their own rights at some point at least seems not entirely implausible. In fact, there's already evidence too that robots, especially those with an anthropomorphic interface, are subject to various forms of mistreatment, if we want to call it that. And for that reason, if robots ever were to develop sentience or some other rights grounding capacity or interest, then protecting them would really become a matter of urgency. So we should care about it. But as the calls for potential robot rights have become louder, so has their criticism. One of the central fears of those who are worried about the implication of robot rights is that we erode the rank and the rights of human beings if we extend rights or legal personhood or other protections to non-human beings like robots. For instance, Nathalie Nevejean, I'm not sure if I'm pronouncing this correctly, but she's an author who wrote a study commissioned by the EU in which she took aim at the proposal that was being put forward to introduce the status of electronic persons for robots. And Nevejean argued that, I quote, assigning person status to a non-living, non-conscious entity would be an error, since, in the end, humankind would likely be demoted to the rank of a machine. And then she goes on to say, robots should serve humanity and should have no other role, end of quote. So an important question for us is then really whether such criticisms are warranted. Because if they are, then the project of giving rights to robots would seem problematic from the get-go and something that we should be fighting rather than potentially encouraging. but perhaps it would be premature because there may be a way in which some of these concerns can be met, showing that maybe robot rights don't necessarily pose a threat to human rights. And really my argument in the paper is that, yes, the skeptics' fears are justified with regard to at least some arguments for robot rights. In particular, I think this is true for the many individual characteristics-based approaches which ground AI in AI rights in individual AI's characteristics or interests. However, these fears can be put to rest if we move away from those individual characteristics theories and instead adopt the group-based approach in law. Now, I should note also that my claim isn't that everyone arguing for robot rights adopts the approach that focuses on individual characteristics. There are other approaches too, and some of them may not run into the problems that the individual characteristics theories have. I do not take a stance in my paper on the potential merits of such alternative accounts. My point is simply that there is an important strand in the scholarship on AI rights that does focus on individual characteristics, and it is this strand that has some problematic implications that need to be countered, as I will explain now. So in this second part then, let us consider the threat that individual characteristics-based theories pose to human rights. The threat that arises is one that arises from the way in which many have argued for robot rights. And the approach, again, that I have in mind is one that calls for an extension of rights and other protections or statuses based on the capacities and interests of individual robots. Take an example, for instance. If we think that the capacity for autonomy is the property that grounds the right to bodily liberty, then some would argue that a robot deserves the right to bodily liberty if it has the capacity for autonomy, right? So simple enough. The focus here is really purely on what the individual robot's characteristics are, not on what group they belong to or any other criterion. And indeed, the fact that robots do not belong to the human species, for example, is viewed as irrelevant for robots' potential to hold such rights. This approach to robot rights is very common, and it bears striking resemblance to how many argue for animal rights. In the animal rights context, it is in fact also very common to argue for extending rights and similar entitlements to animals on the basis of those beings' capacities and interests, say the fact that they're sentient or have an interest in not being imposed unnecessary suffering. One key implication of the individual characteristics approach is that it doesn't stand in the way of giving more or stronger rights to those who possess more or stronger interests. Indeed, this approach even requires doing so. If, for instance, the capacity for autonomy and the interest in living freely is what matters, then those with a stronger capacity for autonomy and stronger interest in living freely will, on this approach, prima facie also deserve stronger autonomy rights. Now, because the individual characteristics approach focuses exclusively on individuals' capacities and interests, it allows for not only a stratification, but potentially even a hierarchization of rights holders. Now, might be objected here that such a stratification is not as big a problem as it might seem. For instance, can't we say that parents have other rights than children? Say, parents have the right to vote or the right to marry that children don't have. And don't we therefore accept that different individuals have different rights based on their different capacities? There's certainly some truth in this, and I don't want to deny this, especially when we're talking about moral rights, which can indeed differ greatly. But things are a bit more complicated in the legal context I want to propose. In law and politics, there has been resistance against the idea that human rights vary depending on the person. And that's because this idea of variation or stratification, and certainly hierarchization, would imperil the idea of equal rights, which has become very central to human rights thinking, at least since 1945, if not earlier. I take equal rights to have two aspects. First, having equal rights means having, or at least being able to have, the same rights. For instance, we might say, while children don't currently have the right to marry, they can achieve a certain degree of maturity at some point in their lives, allowing them to acquire the right then, or actually being able to exercise it at that point, maybe when they turn 18, say. Second, in human rights practice, having equal rights means that every rights holder has rights of the same strength. The right to life of a healthy child, for instance, who has a very long life ahead of them, is taken to have the same strength as that of a 100-year-old and terminally ill person who has only got a few days left to live. The individual characteristics-based robot rights theories can lead to a problematic outcome for human rights regarding both these aspects. First, the individual characteristics approach supports the view that not all humans have or are able to have the same rights, because not all humans possess the relevant characteristics and interests. For instance, some humans are genetically unable to develop the mental characteristics that would enable them to hold rights such as the right to vote. And secondly, the individual characteristics approach also does away with the commitment to equal strength of rights. Say if the infant has a stronger interest in being alive than the terminally ill person, then if we assume that this interest is what grounds the right to life, then the infant would deserve a stronger right to life than the terminally ill person on that account. The problem with this approach to robot rights then is not only that a ladder of rights holder could be introduced, but there's an added problem here when we're talking about robot rights. And that's that humans might not longer occupy the top rung of that ladder. And that's because robots may come to possess some of those rights grounding interests, maybe autonomy or sentience, to a stronger degree than humans. And that would be an issue for humans because it could mean that human interests and rights could on a regular basis lose out to the interests and rights of beings that occupy higher rungs on that ladder. Now, of course, those adopting individual characteristics-based theories can, and some, in fact, have tempered the negative implications of their approach. And they've done so by embracing usually sort of quite explicit commitments to equality. This is an important move that I would really support, but I don't really have time to explore it here in the presentation, but I'd be happy to talk more about it in the discussion, including about my reasons for thinking that this move usually embraces extraneous elements that are in fact foreign to the individual characteristics approach itself. But for us, really, the important takeaway here is that arguments for robot rights that focus on individual robots' capacities and interests, they risk introducing a stratification or hierarchization of rights holders that can have a negative impact on humans' equal rights. Okay. In a third part, let us now turn to how I believe this threat can be overcome by what I call the species membership approach. As I intimated, some of the issues raised by robot rights are very similar to those that we encounter in the animal rights context. And as such, I think it's plausible to at least consider some of the solutions or proposed solution from that context and to see whether they work for robots too. The concrete solution I have in mind is the species membership approach. This is something, as I alluded to earlier, that I developed in a book on animal rights. The SMA proposes that extensions of fundamental legal rights to animals should occur based on an animal's species, not their individual capacities or interests. The SMA focuses on legal rights, not moral rights, but it is open to be used for other legal concepts such as legal personhood too. For instance, if the question is whether a particular pig should have the legal right to bodily integrity, say, then this shouldn't be decided based on whether that individual pig has been demonstrated to possess sentience and an interest in being free from pain. Rather, I think in law, it should be based on the fact that the pig belongs to the species Sus domesticus. Now, note that the SMA itself is neutral on the question as to whether and which rights, or indeed other entitlements or statuses, should be extended to robots. It is simply meant as a useful tool to make such extensions once we decide that we should go down that road. The paper, as those of you who've read it will have seen, discusses in some detail the background of the SMA and why I believe it is a helpful approach. I'll just give a brief synopsis here in the interest of time. The SMA tries to adopt a middle ground between two ideal types or extreme positions, if you like. The individual characteristics approach, which I also call the meritocratic approach, is really just one of these two ideal types. The other one is what I call the aristocratic approach, which refuses to ground legal rights and status in a being's individual characteristics. And instead, it assumes or decides that certain beings, usually humans, should have rights and status from which all others are excluded. So it's really, sort of how the commoners were excluded from noble privileges, hence the name aristocratic. Both approaches have their strengths and weaknesses, and the SMA tries to combine these strengths while limiting the weaknesses. The SMA is meritocratic, or individual characteristics based, if you like, in that it allows extensions of the legal status quo, such as by extending rights to deserving non-humans. But it is also aristocratic in that it makes such extensions based not on individual non-humans' capacities and interests, but on their species membership. This makes the SMA politically attractive, I think. First, it allows the extension of rights to deserving non-humans, which is a valuable goal. But secondly, it also protects humans' equal rights at the same time. However, as I note in the paper, the SMA is also attractive from a pragmatic point of view. Among other things, the SMA is easier to use for legal decision makers than the individual characteristic-based approach, not least because usually judges or other decision makers just don't have the data available on the individual before them, while they may be or can rely on data about species more generally. The SMA, as you'll have noticed, is unorthodox in that it challenges the idea that all forms of species-based criteria should be rejected. My view is that in law, at least, group-based criteria can be useful. However, I'm not making or sort of taking issue at all with, Singer's and others' criticism of species-based approaches on the moral level. And relatedly, my claim is not that the SMA is a morally ideal tool. My claim is only that it is a pragmatically and politically expedient tool in law. Maybe it would be morally desirable to get rid of some, maybe even all group categories. I don't really know, but I do believe that the law cannot operate without categories. And as such, I accept that the SMA can at least help us make the law less arbitrary, even if it cannot eradicate all injustices. Okay, in the fourth and final part now, I would like to say a few words about how the SMA can be applied to robots. Because on the face of it, there's an obvious problem, of course, with doing that. Robots lack membership in a species in the biological sense, right? But I think there's nothing inherent in the SMA that would make it inapplicable to beings who lack a biological species. The job can, in fact, be accomplished by any group-based criterion that provides a sufficiently effective way of capturing the general characteristics of a group of individuals. Because such a criterion serves the same purpose as the criterion of biological species, I just refer to it as quasi-species in my paper. Quasi-species can be defined as a group of beings that resemble each other more than they resemble members of other groups, and that cannot be subdivided into two or more quasi-species. In other words, a quasi-species is really the lowest common denominator, if you like. Now, that, of course, leaves us with the question of what the different quasi-species of robots are to whom the SMA could apply. And answering that question isn't really easy at all because, the idea of robots having rights is still quite speculative at this point. But I think there's at least three factors that are mutually exclusive that we can take into account. First, there's the robot's form of embodiment. Second, there's their algorithmic makeup. And lastly, there's the type of neural network on which they are based. I'm happy to say more about this in the discussion, but just because of time reasons, I'm going to, leave some of the details out here. But obviously, the paper goes into more detail on this. But maybe just let me say that there's many unknowns, and there will be a great diversity of robots, and some of them with natures that may be changing due to the fast-paced technological developments that we're likely going to see. But that doesn't mean that attempts at grouping these robots into quasi-species are futile. even biological organisms can't always neatly be fit into existing species concepts, but that's no obstacle to categorizing them, or most of them indeed, into sufficiently distinct species. Okay, to conclude then, I have argued that the prospect of robot rights may indeed pose a threat to human rights. And that's because of the threat to human rights arising from the common individual characteristics approach to robot rights. To be sure, there may be other threats to human rights arising from robot rights, which my paper does not address. For instance, in a world of scarce resources, would valuable resources required for the enforcement of human rights be diverted for the protection of robot rights? Or would robot rights not have to be balanced against human rights in case they clash with one another? In this respect, some human frights might indeed remain, hence the slightly cheeky nature of my paper's title. However, I argue that applying the species membership approach can at least help alleviate one concern, namely the concern that extending rights to robots would necessarily lead to undermining humans' equal rights and bring about a rights hierarchy that robots may top. Okay, thanks so much for your attention, and I look forward to the discussion later on after the replies.
Thank you very much, Raphael, for that really clear summary of your paper and the bringing together of different perspectives from animal rights to robot rights. That was really impressive. Now, before we hear from Josh, I just want to remind the audience that we'll be having a Q&A in about 20 minutes or so, after Josh has given his response and after Raphael has had a chance to respond to Josh's. And if you wish to participate in the Q&A, first be reassured that you will not be recorded, so you can come online and indicate that you want to ask a question, and so you can ask the question in person. But of course, you could also write your question in the chat. The paper that Raphael and Josh are speaking on today has been pre-circulated, but I will drop the papers in the chat as well as they speak. So now, please join me in welcoming Josh. Thank you very much.
Thank you so much, John. And thank you, Raphael, for a very thought-provoking paper. And also, thank you to all our audience members and to the Queen Mary School of Law. I'm going to go ahead and share my screen. I have a little short presentation. So I am really honored to be here. I was extremely excited when I saw this initiative called Forum on Decentering the Human, and wanted to figure out how I could possibly get involved, because I think it addresses a very important normative question for someone like me who's coming at this as a political scientist who specializes in environmental governance. And what I also want to do before I formally begin is to situate the paper to which I'm responding in the context of the burgeoning robot rights literature, in which we're seeing this wonderful diversification that is, I think, a very logical outgrowth of what has been written previously. And so it's not only thinking about rights between legal and moral, as Raphael mentioned, but thinking about rights and alternatives to rights, which include things like personhood, rights, R-I-T-E-S, that is, entitlements, and in Raphael's own camp, fundamental or foundational kinds of human rights ascribed to robots, which some people say that they are actively not advocating for, like David Gunkel, for instance. So another thing I'll say at the beginning is most of you will find this probably a very nitpicky presentation, and that is quite on purpose, because I think that Raphael's paper was excellent and not only innovative and thought-provoking, but I think actually helps to resolve a problem that animal rights literature has, which I'm going to begin my talk discussing. So I think that I see a lot of value in this approach, and so a lot of the criticism lobbied against Raphael's paper is going to be quite idiosyncratic in nature. So most of you are probably aware of this, and so I'm going to kind of go through this fairly quickly, but there's a lot of criticism on animal rights literature, and I'm just going to mention a few of the issues that have been identified, especially in the robot rights context. The property or properties problem, which property is important, how many properties are the most significant morally or legally, the measurement problem, how do we identify their presence or absence in an entity, the inclusiveness problem, are we protecting wild animals or farm animals or domesticated animals or charismatic megafauna? Animal rights literature has not been able to sufficiently address this issue. And then what I'm going to call the part versus the whole problem, which deals with the little images that you see at the bottom of that slide. And that is, we have seen very productive directions for animal rights come not from animal rights literature, interestingly, although there's at least one article written by Brian Favre several years ago that does explicitly make this point, but is in situating animal rights within the rights of nature, which to me makes a lot more sense. And we have examples of this in contexts like Ecuador and Panama. Ecuador in terms of a famous court case called the Estrellita monkey case, and then the Panamanian law on sea turtles, which was emerged out of the rights of nature law that preceded it. So we're seeing interesting things happen at the national level on the rights of nature, and finding animal rights within that. So that sort of helps to address the part versus the whole problem. But as Raphael correctly identified in his paper, animal rights literature still maintains a very strong fidelity to this sort of very Western Enlightenment and individualist kind of approach, which I'm going to challenge today. To briefly state, and I'm going to develop these a little bit more in detail in the following slides, the nature of my critique of Raphael's approach. I argue that it sidesteps and conflates important concepts, mischaracterizes the properties approach, and overlooks relevant intellectual movements which challenge some of the foundational assumptions upon which his argument is based. So first off, and I've written about this in my book, and there's certainly a lot of literature that has been spilled trying to address the variation across these issues, sometimes conflating them. So this is by no means something specific to Raphael's paper at all, but is the difference between legal entitlements, legal personhood, and legal rights. And as I mentioned, we have at least one or two papers that are already arguing that maybe robots shouldn't have rights, but they should have certain kinds of legal entitlements, which under a kind of Hofeldian rights framework would be a kind of incident, a specific type of right, perhaps, or maybe a more limited vision of what rights constitute. Legal personhood is something that scholars like Wiesa Kirki and Tomasz Pietrzakowski have written extensively about across different non-human entities. And interestingly enough, I was reading a famous biography that was published not too long ago of Cornelius Vanderbilt. And one of the interesting things that was picked up in that book was the evolution of corporate personhood in the United States, which began under some extremely dubious pretenses, where a court reporter inserted language into a famous court decision that then became the basis for arguing that corporations should be legal persons entitled to rights under the 14th Amendment of the US Constitution. And then we saw the evolution over time as corporations became more and more abstract and further removed from their association with any given person or corporate board. We see this sort of a movement away in this kind of abstract way that people who criticize robot rights or animal rights for being abstract or not sufficiently tied to humans are overlooking the fact that corporations have also gone through a somewhat similar trajectory. And then finally, what I take to be the main focus of Raphael's paper are these legal rights, which I think he quite appropriately doesn't specify exactly which ones there will be. There is, if you're interested, some interesting empirical literature which asks people what kinds of rights would they be willing to support. And not surprisingly, we see things like a right to be free from cruelty as the most promising kind of legal right that a robot might be afforded. So I just think it's important to distinguish between these concepts. In terms of mischaracterizing the properties approach, one thing which he sort of hints at, but I'll just develop a little bit further, is what's known as the argument for marginal cases, where in the absence of some condition thought to be necessary for the ascription of moral or legal status, an entity still enjoys rights. It clearly demonstrates that that is not necessary for the enjoyment or affordance of rights. This is a big problem for animal rights literature, although the most sort of intellectually consistent case I've seen is from an animal rights theorist who said, for example, that if a human isn't sentient, you could essentially do whatever you wanted to the human without any kind of moral consequence, which I think people would find pretty objectionable, even if they couldn't specify exactly why they find it objectionable. So the argument for marginal cases is helpful in identifying which factors are truly necessary or sufficient for moral or legal rights and which ones are not. The other one is, again, this is kind of nitpicky, but Raphael talks a bit about hierarchization. And I argue that if you look at some of the literature on animal rights, you may see that there is the idea that there is a hierarchy is somewhat not accurate when you span what has been written on the subject. So this is one example from a very well-known book called Drawing the Line by the co-founder of the Non-Human Rights Project, Stephen Wise. And he sort of comes up with a typology of different kinds of animals and humans for that matter, based on the extent to which they exhibit what he calls practical autonomy. And as you'll see, the furthest to the right, category 1, with a 1.0 rating, is his son, Christopher. But in his text, he mentions that at earlier stages of Christopher's development, he did not possess the same degree of practical autonomy that he does now that he's a more established human. So you could infer from that he didn't think that Christopher would have any kind of fewer rights or less of a claim to moral status, despite the fact that he didn't have the same level of practical autonomy that a full-fledged adult human would. He doesn't exactly explain why that is. But you can also see that there's a change over time in the development of animals, and there are changes or variation in the kinds of animals that we're talking about. So, and for I think 2 or 3 of those categories, Wise says that they are granted or eligible for certain kinds of elevated moral status. I think it's the category 4 and maybe category 3 that you wouldn't have that status. So yes, there's a little bit of a hierarchy going on here, but also there's a lot of lumping together of different kinds of animals, including humans, that also varies across species and across development levels. And then there's another paper, which I like to cite from Kai Chan, which talks about the idea that if there's a non-zero chance that something possesses a quality like consciousness or sentience, then it should be sort of an all or nothing proposition, and we should defer to having a more cautious kind of practice in which we extend moral rights on the basis that it could be morally significant, not that it definitively is. So I just want to challenge the idea that it necessarily results in a kind of hierarchization that pits animals against humans and their interests against one another when conflicts arise. Another thing which is important, and given the space that Raphael had to write in, I certainly don't completely fault him for this, but I want to speak to more of the tenor of the oversight that happens throughout the literature on robot rights, in addition to animal rights, and that is to highlight some intellectual movements that challenge some of the underlying assumptions upon which that literature is based. And these include, but are not limited to, critical environmental law, the legal ontological turn, new materialism, and the relational turn, all of which challenge Eurocentric hegemonic notions of how we understand knowledge and the accumulation of knowledge in the world, and what kinds of beings matter in the world. It is only when we dismiss these kinds of cognate approaches and intellectual movements that it becomes more tenable to accept that there is in fact a hierarchy. And going back to the nature of the forum on decentering the human, the very fact that this is even a conversation suggests that maybe we need to assert some kind of pushback against the dominance of an exclusively Eurocentric, anthropocentric perspective, because it's not sufficiently normatively attuned to the conditions of the Anthropocene or what we understand to be moral obligations moving forward. So my proposition here, which might seem somewhat orthogonal to Raphael's paper, is I think that we could do very good by ourselves if at the beginning of arguments, of papers, of books, scholars are required to disclose certain foundational assumptions of their work. And I list 3 questions that they should have to answer, which will help us to kind of figure out their orientation and honestly the degree to which it can be dismissed for discounting important counters to their approaches. So the first question is, to which jurisdiction or jurisdictions and non-human entity or entities does your discussion apply? 2, which theoretical paradigm or paradigms and worldviews inform your perspective? And 3, how would you describe the ontological orientation of your work, whether it's anthropocentric, biocentric, ecocentric, infocentric, or otherwise? If we have the answers to these questions upfront, I think that we can do a much better job of having just these kinds of debates. Now, this is no shade on Raphael's paper, which was very elegantly written, and it was very easy to kind of identify his orientations. But I think that for other works, it would be very useful to have this kind of information presented upfront. So I want to close by saying that I think my sort of normative argument here is that we need to embrace epistemic humility in order to achieve a more just, more than human world in which humans are decentered and other non-humans can actually find themselves in an elevated place of moral or legal importance, and that the species membership approach, while certainly a step forward, even for the animal rights, actually, it highlights a need for us to consider how we can transcend some of our Eurocentric Enlightenment limitations that frustrate the degree of innovation that might be possible in thinking around this area. So that's all I have to say. I'm really interested in the questions and Raphael's response, and I look forward to the rest of our conversation today. So thank you very much.
Thanks to you, Josh. That was a wonderful presentation and a challenging one. Just to note that one of the first events that the Forum on the Center on the Human hosted was an event on the ontological turn in law. So many of the much of the literature that you have cited is some of which much of it is taken into account by at least some of the researchers in the forum. Okay, so I will invite Raphael to respond to any points you may wish to in relation to Josh's comments. And after that, we will stop the recording, and I would invite the audience to either post questions, comments in the chat, or to raise their digital hand to signal that they want to intervene. Okay, Raphael, you have the floor for about 5 minutes.
Yeah, thanks so much. And thanks, Josh, for these really thoughtful comments. I think it happens very rarely that people actually seriously engage with one's work. And so I'm really grateful for you to have taken the time to read the paper so carefully. And, I agree with a lot of what you're saying, maybe all of it really. And I really like this idea of, embracing epistemic humility. So I would certainly want to second that. So I want to keep my replies short because I want to hear what people think about all of this stuff that we've been throwing at them. But maybe very briefly going through the sort of 3-part structure that you were outlining, Josh. Yeah, I think I'm entirely on board with you. We need to keep concepts like legal personhood, legal rights, legal entitlements, as you call them, separate. We do some of this in the animal rights law textbook that John alluded to in his introduction. And it's true that my paper doesn't really distinguish between these concepts, but I was hoping that that doesn't necessarily lead to a conflation of them. The only reason really why I didn't distinguish them was that distinguishing them isn't necessary for the purposes of applying or really sketching the SMA. In other words, whatever the criteria are for legal personhood, whatever the criteria are for thin rights or thick rights, or legal entitlements and legal rights, as you call them, the SMA can be a useful tool for exercising them if your goal is to not undermine humans' equal rights. But I would certainly second this idea of being clear about what we mean by these terms and by not conflating them. Although, having said that, I have found it interesting to see, looking at some of the animal rights case law, at least in the few cases that have been successful, how the judges didn't seem too bothered about drawing very neat distinctions, and what's legal personhood exactly, and do you need to cease to be a property to become a legal subject. There are quite a couple of cases now that more or less just sort of brush over these distinctions and just say animals can have rights, animals can be legal subjects, and they don't deal as much with these distinctions as we scholars might like them to do. So on the second point, yeah, I think that's very helpful too. I think I should certainly clarify my method, and part of the problem is that I do a lot of that in the book, and the paper is a spin-off, and I just didn't do a good enough job explaining that I am indeed very much open to diversity within the individual characteristics approach. And the method really that I adopt is a Weberian sort of ideal type. So I take existing theories and I try to show what the logical conclusions are following from some of these theories. Now, you're quite right to point out, Josh, that some theories are hesitant to go all the way to where I think their premises would take them. And I mentioned Alistair Cochrane in the paper, who does have an explicit commitment to equality that sort of tempers some of the negative implications of his account, as I see it. On Stephen Wise, I think it's an interesting one, because in his litigation, at least, he uses two arguments: the autonomy argument, which is very much an individual characteristics argument. So if you have the required degree of autonomy for legal personhood, then you should have legal personhood. On that metric, the young Christopher, at least at a point when he doesn't have the necessary autonomy yet, would not qualify for legal personhood on Steve's own theory. But he's got another sort of concept that he uses, another argument, which he calls the equality argument, which basically goes, well, human children, have those rights in the legal personhood. So an animal that has the same level of mental complexity as those children should be treated the same. So it's about, treating like cases alike. I think, in other words, he really does bring in the end, an extraneous argument, one that's not based on individual characteristics in the end, but on, equality. Let's just treat them the same as humans, regardless of what their mental complexity might be like. That is not really in tune with his individual characteristics approach, but a really good thing to adopt. So I don't want to suggest that I'm opposed to it, or that indeed I ignore these differences, but it's certainly helpful to highlight them. And then lastly, yes, I think you're absolutely right to point out there's a vast variety of different argumentative strategies. And yes, I hope that by just focusing on what the sort of standard method is, or something that we come across very often, I have really sort of taken down potentially that one narrow approach. But I didn't mean to suggest that there are not other potentially more fruitful approaches out there. My paper just didn't deal with them at all, because I wanted to have a narrow focus. But something I'd be interested in, and this may be an invitation to start off the discussion, I don't know, but Josh, this idea of I think you call it Latourian flat ontology in your response, or this idea of new materialism, all matter has agency. I find these ideas very interesting, but I sometimes wonder how much purchase they can have on the ground, if you like, in courts, in other sort of lawmaking bodies. My SMA proposal is in the spirit of what Cochrane has called realistic utopia, right? It accepts that there's some constraints. I don't like them. I'm not necessarily the biggest fan of the liberal approach myself, but it's the approach that governs many legal systems at the moment. So for me, it's often a question of how radical do I want to be? Because it seems to me the more radical I am, the more just maybe my theory is, but the less likely it is to be adopted in practice. And the less radical it is, the more it is open to criticism, such as, this isn't ideal, you're just replicating Eurocentrism and what have you. And I take that. The question is really, where should we find the right balance? Should we be idealistic? How do you see this, and how do you see those new and very refreshing concepts play out potentially in practice? That would be my opening question, maybe, for the discussion.
Okay, Raphael, thank you very much for that short response. And I would invite Ghosh to stop the recording, and so that we can proceed to the next Q&A section, which should last for no more than 35 minutes.